Hello everyone, our topic is about tourism tort and damages. Objectives: define the law of tort and determine the purpose of it existing. Analyze the element of tort. State the difference of fault, negligence, and damages. Restate the doctrines of negligence case. Define the law of the tort and determine the purpose of it existing. A tort is an act or omission that gives rise to injury or harm to another in amounts to a civil wrong for which court imposed liability. In the context of tort, injury describe the invasion of any legal rights, whereas harm describe a loss or detriment in fact that an individual suffer, and the purpose of tort law is to compensate person for private wrongs. This could be international wrongs such as assault and battery or conversation of another property, or accidental wrong in which someone suffer loss or damages because of someone not acting carefully. Ang tort ay isang gawa o pagkukulang na nagdudulot ng pinsala sa iba. Sa konteksto ng tort, inilalarawan ng pinsala ang pagsalakay sa anumang legal na karapatan, samantala ang kapinsalaan ay naglalarawan ng pagkawala o kapinsalaan. Narito ang tatlong uri ng tort: intentional tort, negligence, and strict liability. Intentional tort. An intentional tort is when an individual or entity purposely engage and conduct that causes injury or damage to another. For example, striking someone in a fight would be considered an intentional act that would fall under the tort or of battery, whereas accidentally hitting another person would not qualify as intentional because there was no intent to strike the individual. Ang intentional tort ay kapag ang isang individual ay sadyang nagsasagawa ng kilos na nagdudulot ng pinsala sa iba. Halimbawa, ang paghampas sa isang tao sa isang pakikipag-away ay maituturing na isang sinasadyang kilos na sa ilalim sa tort o battery. Samantalang, ang hindi sinasadyang pagtama sa ibang tao ay hindi magiging komplikado bilang sinasadya dahil walang intensyon na hampasin ang individual. Halimbawa ng intentional tort: assault or pag-atake, battery, false imprisonment or huwad na pagkakakulong, conversion, intentional infliction or emotional distress, fraud, deceit, panluloko, trespass to the land and property, defamation o paninirang puri. Pangalawang uri ng tort, negligence. There is a specific code of conduct that every person is accepted to follow, and the legal duty of the public to act a certain way in order to reduce the risk of harm to others. Failure to adhere to this standard is known as negligence. Mayroon isang tiyak na code ng pag-uugali na inaasahang sundin ng bawat tao ay isang legal na tungkulin ng publiko na kumikilos sa isang tiyak na paraan upang mabawasan ang panganib ng pinsala sa iba. Ang hindi pagsunod sa mga pamantayang ito ay kilala bilang kapababayaan. Halimbawa ng negligence tort: slip and fall accident, car accident, truck accident, motorcycle accident, pedestrian accident, bicycle accident, medical malpractice. Ang pangatlong uri ng tort ay strict liability. Lastly, there are tort involving strict liability, strict or absolute liability applies to a case where responsibility for injury can be imposed on the wrongdoer without proof of negligence or direct fault. If a case is a strict liability tort, the victim has a right to recover even if the responsible party took every precaution and didn't hurt them intentionally. The only thing the victim must prove is that they were hurt because of the other person's actions. What matters is that an action occurs and result in the eventual injury of another person. In lawsuit such as this, the injured customer only has to establish that their injuries were directly caused by the product and question in order to have the law of their side. The fact that the company did not intend for the customer to be injured is not a factor. Defective product and dog bite causes are prime example of when liability is maintained despite intent. Halimbawa ng strictly liability tort: defective product, animal attack, abnormally dangerous activities.
Hello everyone, our topic are analyze the element of tort. International tort. An international tort is when an individual or entity purposely engages in conduct that cause injury or damage to another. For example, strike someone in a fight will be considered an international act that would fall under the tort of battery where areas consistently hitting another person would not qualify as international because there was no intent to strike the individual. However, this act may be considered negligence if that a person hit was injured. A tort is an act or omission that give rise to injury or harm to another and amount to a civil wrong for which court impose liability. In the context of torts, injury describe the invasion of any legal right, where area harm describe a loss of detriment in a fact that of individual suffer. Example of international tort: assault, battery, forced imprisonment, commission, international infliction of emotional distress, truth of deceit, trespass to land and property, definition. Negligence. There is a specific code of conduct that every person is expected to follow, and a legal duty of the public to act a certain way in order to reduce the risk of harm to others. Failure to adhere to this standard is a no of the negligence. Negligence is the fundamental legal basic for a personal injury claim, and it plays an essential role of determining whether an injury victim will be able to receive compensation in how much compensation they may receive. Example of negligence tort: slip and fall accident, car accident, truck accident, motorcycle accident, pedestrian accident, bicycle accident, medical malpractice. Strict liability. Lastly, there are two in boiling strike liability. Strike of absolute liability applies to case where responsibility for an injury can be imposed on the wrong door without full proof of negligence or direct proof. If a case is a strike liability tort, the victim has a right to recover even if the responsible party took every precaution and then hurt them international. The only thing the victim must prove in that they were hurt because of the other person action. What matter is that an action record in research in the individual injury of another person. Strike liability is an important factor in maintaining safety in high risk environment by encouraging individuals, employer, and another parties parties to implement the mean of prevent injuries and damage. Example of the strike liability: effective product liability, animal attack, dog bite lawsuit, abnormally dangerous activity. The four elements of every successful tort case are duty, breach of duty, causation, and injury. Duty. The first elements of negligence is duty, also referred as as duty to care. What is a duty? In its most simplican, simpli, simplistic terms, it is an obligation to other to or not do something that will harm someone else. Think is duty as obligation. We all we, we all have a duty or an obligation to act reasonable or reasonable refrain from certain action in such a way as to not cause injury or harm to another person. For example, as driver of automobile on public road, we all have a duty to follow the rules of have road. It is on obligation as a licensed driver to do so. We understand that rules like speed limit are imposed to protect others. A reasonable person understand that the failure to follow the rule of the road may result in harm to another person. A duty is something that someone is effect of required to do parents. For example, has a duty to take care of their children. You have duties toward your parent. A teacher has a duty to educate student. Brace. Once a plaintiff has established and proved that a defendant all on a duty of care to the plaintiff, the second element of negligence a plaintiff must prove is a breach of the duty of care. This is when a person or company has a duty a duty occur of the another and affect to life up to that standard of care. A plaintiff must prove that the defendant is act or mission cause the plaintiff to be exposed to a considerable risk of injury and or harm. In other words, the defendant failed to meet their obligation to the plaintiff and therefore put the plaintiff in harm way. A data breach is an incident where information is stolen or taken from a system without the knowledge of authorization of the system owner. A small company of or large obligation will suffer a data breach. Stolen data may involve sensitive, probi- proprietary, or confidential information such as credit card number, customer data, trade secret, or matter of national security. Causation. The third elements of negligence is causation. There are two types of negligence causation: actual cause and proximate cause. Actual cause is a something referred to as cause is fact. It means that but for the negligence act of omission of the defendant, the plaintiff would not have been harmed. This is known as to but for it is. For example, driving is passing through an intersection when a green light, driving B run the red light, and the strike driver as behind in the injuries driver A clearly but for the running of the red light by driving B and driving A behind would not have been struck by driver B and driver A would not have been harmed. Causation is the causation is causal relationship between the defendant conduct and will result in other court causation provide to mean of connecting conduct which a resulting effect typically an injury. The last in harm the last is harm. Harm can come in many forms. It can be economic like medical costs and loss. We if if can be not economic like pain and suffering to extreme. Emotion distress, it can't be harm to a person body, to a family members of to properly. However, if one if not harm, it's some way the failed elements of negligence is not meet in the lawsuit is negligence will not provide. A risk is a risk is a potential harm of injury associated which the research that a reasonable person would be likely to consider significant in ceasing within or not be in participate in the safety in the study. The concept of risk include the comfort burden of inconvenience, inconvenience the subject may experience as a result of the research producer. Thank you.
The difference between fault, negligence, and damage. What is fault? Fault is responsibility for failure or wrongful act that a person has done, while negligence means failure to take proper care in doing something that result to a damage or injury to other person. And damage means a physical harm caused to something in such a way as to impair its value, usefulness, or normal function. Proving fault and damage in person injury cases. Negligence. Negligence is the most personal injury lawsuit is the it is when people are required to conduct themselves according to the prevailing standards of behavior to avoid unreasonable risks of harm to others. If a person violates standard of state and injury, they will need to compensate the victims for any losses. There are some related issues to negligence theory. First, negligence per se. Negligence per se it is applied when conduct is violation of a law that cause harm. Negligence per se are also called negligence in itself. And number two, the difference between comparative negligence and contributory negligence. It is the contributory negligence is a doctrine bars plaintiffs from collecting damages. This is usually found partly at fault for their accident-related injuries, when comparative negligence is a doctrine doctrine or does not. And number four, vicarious liability, also known as imputed liability. This is an attachment of responsibility to a person for harm or damages caused by another person in other negligence, lawsuit, or criminal persecution. Pres- Persecution. And number four, third party liability. Liab- Third party liability is a type of coverage that financially protects you if you're considered responsible for any damage or injury to other person or their property. Number 5. Strict liability. It means it is a standard of liability under which a person is legally responsible for the consequences and observe of fault or criminal intent on the part of the defendant. And number 6, last, Actu- actual and proximate case. Actual cause, or also called cause in fact, is straightforward, while proximate cause means legal cause or the one that law recognizes as the primary cause of injury. That's my report. Thank you.
Economic damages, the monetary value of total or partial destruction of physical assets existing in affected area. Direct economic loss nearly equivalent to physical damage. Non-economic damages refers to compensation for subjective, non-monetary losses such as pain, suffering, inconvenience, emotional distress, loss of society and companionship, loss of consortium, and loss of enjoyment of life. Punitive damages are also called exemplary damage, which are damage assessed in the legal process to punish a defendant or negligence. The defendant is usually a company or other large entity. Examples would medical malpractice cases or product liability cases. Tort reform refers to change in the civil justice system, in common law countries that aim to reduce the ability of plaintiffs to bring to tort litigation or to reduce damages they can receive. A plaintiff suing on the basis of negligence will have to show the defendant's duty of care to the plaintiff, the defendant's breach of duty, actual and approximate caution, linking the breach to the harm and actual losses or connection to the losses that the law recognizes. An event that is too remote from the harm may not be recognized as approximate cause. Negligence can arise in any content, including motor vehicle, accident, or products liability. For example, a motorcyclist who is injured in a truck collision will have to show that the truck drivers or another party's action fell below the standard of care. An example of action that fall below the standard of care would be a truck driver who runs a stop sign, or in another example, a consumer may need to show that a manufacturer's design fell below the standard of care to recover for a defect that caused an injury. Establishing a duty of care. To establish a defendant's duty of care, plaintiff needs look to laws, rules, or guidelines. However, in the absence of a law, a defendant may simply have a duty to act reasonably, which may be a very fact-intensive analysis. Professionals such as physicians, nurses, and lawyers must live up to the standard of care expected of the typical individual and the specific profession or specialty. A professional who fails to meet the standard of care and acts negligently can be used for malpractice.
Negligence in tort law. The rules of res ipsa loquitur and negligence per se. Res ipsa loquitur, Latin for "the thing speaks for itself," is a legal theory where in the facts and circumstances surrounding an injury allow the court to presume the negligence has occurred. In an ordinary negligence case, the plaintiff must prove that the defendant on the plaintiff a duty and that his conduct failed to measure up to that duty. However, under res ipsa loquitur, the defendant's negligence may be presumed and does not be proven. So, res ipsa loquitur, Latin for "the thing speaks for itself," na ibig sabihin sa Tagalog, tignan mo lang, alam mo na. Na kapag napaka-obvious or halata na ang isang bagay, ay maaari na natin i-presume na yun talaga ang nangyari. May mga bagay-bagay sa korte na hindi na talaga dapat patunayan. Example is, gusto mong patunayan ang kapabayaan ng isang doktor, so therefore, pinakita mo sa korte ang isang example ng x-ray, yung makikita sa loob ng tiyan ay may naiwan na gunting. Kailangan pa bang patunayan na yung nag-opera ay negligent? Hindi na, because the thing speaks for itself. Obvious na, tingnan mo lang, alam mo na. Yan ang ibig sabihin ng res ipsa loquitur.
Hello everyone and sir. My name is John Alexis Verdida. My topic for today is about negligence per se. Negligence per se is applied when conduct that is a violation of a law, whether a criminal statute, ordinance, or administrative order, causes harm because violating the law is inherently considered negligence behavior. That the defendant violated the law inherently proves that he breaches his responsibility, that his action caused injury to the plaintiff. In other words, the elements of causation and damages still must be proven. Res ipsa, locator, and negligence per se are both doctrines that assist in proving breach of duty. And in certain negligence cases, the former allows negligence to be inferred from the circumstance, and the latter allows it to be inferred from a violation of law. Both have many applications that allows causes of action to go forward where there is a lack of direct evidence proving negligence. What is negligence per se? Ito ay nilalapat kapag ang pag-uugali ng isang paglabag sa batas ay nagdudulot ng pinsala, dahil ang paglabag sa batas ay tinuturing negligence na ugali. Kapag ang isang nagkasala ay lumabag sa batas, ito ay mapatunayan na siya ay lumabag sa kanyang mga responsibilidad. Dahil sa kanyang ginawa, nagdulot lamang ito ng pinsala o hindi maganda sa nagrereklamo. Ang res ipsa, locator, at negligence per se is both doctrines na tumutulong para mapatunayan ang paglabag sa nasasakdal sa kanyang tungkulin. They both have many application na nagpaintulot sa mga sanhi ng kilos o pagkilos na nagpatuloy kung saan napatunayan ang direct evidence ay mayroon kakulangan at napabayaan. Yun lamang po. Maraming salamat.